Welcome to Washington Legal Foundation. This is our web seminar series. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies of the Foundation. For those of you not familiar with the Foundation, we are in our 47th year of free enterprise advocacy and education. This is part of our educational side. For those of you interested in learning more about us, spend some time on our website at wlf.org. And certainly welcome to answer any questions you might have about the foundation. Just shoot me an email. So on his return to the perch of chairman of the House Energy and Commerce Committee in 2007, Representative John Dingell famously quipped, "As the Lord High Executioner said in the Mikado, I have a little list." One would imagine that some incoming heads of Senate and House committees, especially those in the Senate, are having similar thoughts. With Congress likely to continue struggling at its job of passing legislation, oversight and investigations will once again be at the forefront of business in both chambers. One question entering the 119th Congress is how much business will be at the forefront of oversight and investigations. The political and ideological climate that animate Congress's actions is rather unique, so any traditional assumptions that might apply to Republican control of the Senate and the House, not likely to apply in all cases. At a time of uncertainty, the best thing to do is be prepared, and we're here today to help you with that. WLF is pleased to be hosting this webinar and proud to be joined by three experts at the craft of managing congressional oversight and investigations. I will introduce them. Well, Moschella is co-chair of Brownstein, Hyatt, Farber, Schreck's LLP's Government Relations Department. He served at the Justice Department as Principal Associate Deputy Attorney General and as Assistant Attorney General in the Office of Legislative Affairs. In Congress, Will served on the House Judiciary Committee as Chief Oversight Counsel, Chief Legislative Counsel, and Parliamentarian. Alice Lugo is Senior Counsel at Brownstein Hyatt and former Assistant Secretary at the Department of Homeland Security. In that capacity, Alice was the Principal Advisor to DHS Secretary Alejandro Mayorkas and senior leadership on all congressional engagements, hearings, and matters before Congress. Prior to her service at DHS, Alice served as counsel and chief counsel to senior members of both the U.S. Senate and House of Representatives. Greg Brower is co-chair of Brownstein Hyatt's Government Investigations Practice Group. Prior to returning to the firm this past March, Greg served as Chief Global Compliance Officer for Wynn Resorts. His career in public service has included positions as Nevada's top federal prosecutor, head of the FBI's Office of Congressional Affairs, Inspector General for the U.S. Government Publishing Office, and chairman of the Judiciary Committee of the Nevada State Senate. Most importantly to us here at WLF, he has been a long-serving member of our legal policy advisory. Just to remind you that we are recording this, and if you have any questions for our speakers, we will address them towards the end of the program. Please put those questions in the Q&A function located in the Zoom webinar toolbar. So let's start off with a brief discussion of Congress's oversight powers and responsibilities. Will, can you give us a brief overview of what we mean when we talk about congressional oversight?
Sure, Glenn, and thanks for having us. If this is a topic that could be an hour-long CLE, so give me the hook if I go on too long. But oftentimes a client will say to us, "Hey, I got this letter from this member of Congress, this committee chair. What is it? Why can they send this? I'm kind of familiar with our regulator and our regulator's authority. I certainly am." Familiar with civil litigation, but how is Congress getting involved here? And of course, Congress has a very broad authority to conduct oversight and investigations, and the Supreme Court has said that its authority is as broad as its legislative activity. And it really stems from the notion that Congress needs to be fully informed when crafting legislation. And so, a very, very broad authority. Congress cannot exercise prosecutorial authority. The Supreme Court has said that it can't investigate, merely to investigate someone's personal conduct. But courts are fairly deferential on what is within Congress's authority. And so long as Congress can tie its request to a legitimate legislative purpose, it's very likely going to be able to proceed. For those of you who are familiar with the Congress's Commerce Clause power on this call, think of how broad that is, right? You remember McGrain you remember your, I was about to say McGrain versus Doherty. I don't want to confuse cases here. Wickard versus Filburn and Gonzalez v. Raich. I mean, the extent of Congress's Commerce Clause authority is very, very broad and is basically as extensive as that the Commerce Clause will allow it.
What? I can't hear you, Glenn.
Sorry. I assume, Will, that it would make a whole lot of sense for most people who are being targeted by congressional investigations to challenge Congress's authority. There isn't much of a chance that you succeed in a federal court on that. Now you're muted, Will.
We will get this right. So there are some defenses. And so Congress's authority stems from its constitutional authority to legislate, but it can't trample others' constitutional rights, for example. And so oftentimes a witness will not comply by asserting their Fifth Amendment rights. We've helped clients in the past where Congress's authority really looks like they're trying to probe First Amendment protected activity. And we've been engaged in a couple high-profile battles there. Again, First Amendment says Congress shall make no law, and because it doesn't have authority in that sphere, that would be a valid defense. We can talk about some other things that really get into the House and Senate rules about things that one might do. But for example, a committee that operates outside of its jurisdiction probably can't look into that matter. Committees of Congress are delegated by the full body, either the House or the Senate, the ability to conduct oversight over particular issue areas. There are a couple committees in Congress that have very broad oversight jurisdiction. So the Oversight Committee in the House and the Permanent Subcommittee on Investigations in the Senate have very broad authority. And so before you lodge a jurisdictional complaint against an exercise of oversight, you really got to kind of dig in with counsel, somebody who understands the House and Senate rules and the rules of the particular committee in question.
So Alice, what are the distinctions between the Senate and the House in terms of how oversight works?
Yeah, I mean, they each have their own authority to conduct investigations, so they don't necessarily have to coordinate, and often they do not. And it's very much, as Will mentioned, based on the jurisdiction of that committee. And House and Senate rules are distinct, and we can get more into this later on. I know Greg is going to speak on this in more detail on the different tools that can be used in oversight, such as, for example, a subpoena. Generally speaking, in the House, the vast majority of committees, the chair can unilaterally issue a subpoena without the consent of the ranking member. Distinctly in the Senate, that usually is not the case. Usually the chair would consult and get the consent of the ranking member to issue a subpoena. Also distinctly and very timely, the nominations process, right? In the Senate, that's a very unique role for the Senate to participate, advice, and consent in the confirmation process of the presidential picks for the cabinet. And that will be happening very soon. But that's also an ability for senators to talk about policy issues, to ask questions of the nominee on an issue that's important to them, to see how they respond. What's that nominee going to prioritize in XYZ issue area? I know some of our clients have a lot of issues that they care about, and they're gearing up for those hearings and are very interested in how a nominee is going to answer a question on a variety of issues, ranging from immigration to questions about financial services, et cetera, where the nominee is going to prioritize certain things. And that's an ability and a role that the Senate can play. And we will be working on making sure some of those questions are asked in those nomination hearings.
So are there material differences between the committees in terms of the procedures and the rules that those who are being considered targets should be concerned with?
I think generally the tools, the subpoenas, depositions are going to vary between the chambers, and having counsel who's familiar with them, familiar with House and Senate rules to be able to advise on what a certain chair can or cannot do, etc. But they're very similar in the ability to have oversight and investigation authority on a variety of issues based on the jurisdiction of that committee.
So, Greg, there are obviously differences in terms of the authority that the party in power would have versus the minority party. What are the different responsibilities of the chair of a committee versus the ranking member?
Yeah, Glenn, it's a big difference, and in fact, in any legislative body, it's very good to be in the majority. The majority gets to set the agenda, gets to set the schedule, and in this particular context, it's the majority in the form of the committee chair who has pretty significant enforcement power in the context of a congressional investigation. So, and we have clients frequently who will get a letter, let's say, from a ranking member of a committee, or even a member who's not a chair or a ranking. And it's, on the same sort of official looking letterhead, and to the layperson, it looks like a request or a demand that can't be ignored. And most often we will advise clients that you shouldn't just ignore it. But the biggest difference between a request from a chair and a request from a ranking is the potential enforcement power behind a chairman's request versus what I would referred to as more of an aspirational request by a ranking. But again, oftentimes even a request from a ranking member or a backbench member of a committee generally shouldn't be ignored for a lot of different reasons, and the devil's in the details in terms of who it is, the type of request. One Congress's ranking is the next Congress's chair, right? Sometimes. So depending on who the client is and what the nature of the issue is, it often makes sense to cooperate with a request, even though the request may not be from a chair and there may not be ultimate enforceability behind the request. So again, the devil's in the details.
So I would imagine one of those details would be, I'm sure there are run-of-the-mill members of committees, and then there are members of committees that could be former chairs of the committee, or those that carry a bit more gravitas with them. And I have to imagine that you would treat them a little bit differently in terms of a request from them versus those that are just new on the committee, or those that do this all the time and just throw letters out there.
Yeah, that's right, Glenn. And in fact, another thing that is often a consideration is a ranking member's request that may or may not be completely, enforceable could turn into a joint request with the chair if the target of the request simply ignores it, and the ranking can then convince the chair that, look, Company X is disrespecting the committee. I maybe we should get together on this, and the chair may do that. Now, all of a sudden, it's a bipartisan request with real enforcement power behind it, and that's a situation a potential company client target doesn't really want to get itself into if it can avoid it.
So it's clear from talking to you and others over the years on congressional oversight that one of the things that you always stress is that this process is not like litigation, and the whole process of collecting information isn't like discovery. Will, can you sort of lay out what are the ways that congressional committees and the staff look for information, seek out, do hearings, those sort of things, and how they're different from the sort of run-of-the-mill discovery process in the context of litigation?
Sure. So first of all, there isn't really a neutral arbiter. There's no judge to appeal to at the end of the day. And so some of these things, you'll get an oversight letter, and it'll say that they're doing it pursuant to, rules 10 and 11 of the House of Representatives. There are some rules in there that you can hang your hat on, but really, this is a process that's driven, by a committee chair. Now, oftentimes, you might, in civil litigation, you might start with a demand letter that kind of looks similar to a letter that comes from a committee chair. But make no mistake, it's wildly different. You might receive the letter after it's already appeared in the press, for example, and you might your press office may have already received a phone call from a reporter asking about this particular request long before your general counsel's office has seen the letter or the CEO has seen the letter. Big differences right off the bat. Oftentimes, a committee chairman or even a rank and file member trying to make a political point. Just one side note to Greg's answer, just to give an example of a request that can come from somebody other than a committee chair. Recently, the Congressional Black Caucus sent letters to something like 100 plus companies asking about where they stand on their DEI commitments. Those were in the press within minutes of hitting send on those letters. So the subpoena process is also a little bit different. But as Alice said, at least in the House of Representatives and at the Permanent Subcommittee on Investigations, committee chair basically has the ability to issue subpoenas. This has been a change over my career. When I started on Capitol Hill in the early 90s, committees voted on subpoenas, and that has changed, over time. Committees didn't have deposition authority. Most committees have that now as well, particularly focusing here on the House of Representatives. And so, those tools are now utilized, much more frequently. And then finally, something that's been used really in the last 5 or so, 6 years, it's a relatively new development, is the transcribed interview. And so committee staff will use the shorthand TIs, because you have to have an acronym for everything in Washington, but they will now do transcribed interviews without a subpoena, and then you'll enter into a negotiation over what the terms, conditions of that interview are.
Hey, if I could mention one more thing.
Sure.
Will, thanks for sitting a couple of minutes, because I just I think pretty deftly, for me anyways, transitioned from a dead laptop battery to my phone. So I hope I made that look seamless. But what I was just going to echo is the litigation comparison. I'm a 30-year litigator, and I really find the differences and the similarities fascinating between a good old-fashioned civil suit and a congressional investigation. But I think it's important for clients facing an investigation or potential congressional investigation to really make sure that the team representing them has both skill sets. There is enough of litigation-like things about a congressional investigation that make litigation experience and skills important, especially when you're talking about some investigations which involve a lot of document production, witness interviews, perhaps hearings. That's a lot like the things that civil litigators do every day. But the biggest difference, I think, is that having simply a litigation team, even a very good litigation team, handle a congressional investigation misses out on the relationship aspect of working with the Hill. It's the relationship with the committee staff, relationships with members, which allow counsel to effectively negotiate the scope of an investigation and ultimately bring it to a resolution that is a good result for the client. So it's really a combination of the two, and clients are well advised to make sure their team has both litigation and capital relationships in this specific context to be effective.
So sticking with the production of information theme, what sort of privileges exist for those who produce information to congressional committees? Do they have any way of protecting trade secrets, those sort of things?
Short answer is not much.
Well, as also.
Oh yeah, go ahead.
Yeah,
sorry,
go ahead.
Will. I should have said who I was like that.
Well, Yeah, let me try. Will alluded to it earlier, and as he just said, not much is the great answer, the right answer. The constitutional privileges, and Will mentioned the Fifth Amendment right against self-incrimination. That is, alive and well, and something that is honored by Congress. It's never a good thing for a witness to have to, especially at a hearing, right, a public hearing, to take five in front of the world and C-SPAN. But it's a privilege that Congress does recognize. Other what we might call common law privileges, such as the attorney-client privilege, and then other practical, even if you don't call them privileges, things like that are very common in civil litigation, whereby protective orders can be obtained so as to not have to produce confidential or proprietary information. Those are very much negotiable. It's kind of depends on the committee, depends on the committee chair, depends on the context and the issues at stake. But again, experienced counsel in the context of an investigation will negotiate the scope to take into account things like that and make sure the client's interests are not compromised in a way that would be detrimental for the client, right? So that's all, like everything in this context, that's all negotiable, but there is no, recognized tradition of recognizing the attorney-client privilege in this context. I will say add one footnote in that regard. In the recent Mazars case, in this context, no less than Chief Justice Roberts mentioned in the opinion, and it's probably best described as dicta, but the chief did indicate that that recipients of congressional subpoenas have long been understood to retain common law privileges, such as the attorney-client privilege. That raised a few eyebrows when he said it, because that hasn't really been the understanding in this business, but good for him for saying it. It makes sense, and it's the way it should be, but that has really not been the tradition in large part.
Before we move on to sort of Congress. Oh, sorry, go ahead, Will. Yeah.
I was going to say, and certainly not Congress's position, right? Congress is traditionally takes the position that since their oversight authority stems from their constitutional legislative authority, that only a countervailing constitutional privilege will suffice to overcome their subpoena. So the reason why these cases we don't have real good law on this is because Congress hasn't really pressed this question. Usually it's subject to negotiation, accommodation, and at least in my experience, congressional investigators are not interested in information covered by the privilege. You might wind up having some crime fraud types of dialogues with committee counsel on particular matters, particularly if they're high profile. But those are few and far between.
Alice, did you want to add anything on the privileges or any of the issues before we move on to sort of broader questions?
I think my colleagues have covered it. The only thing I would say, comparing investigations to litigation, is, the prep of the individual who's testifying, making sure they are very well versed, that, there is no objections or you can't ask that questions. Members of Congress have a very, they can really ask whatever they want. And answering it and preparing for potentially an adversarial question is important, and is somewhat similar to in the litigation sense, but that's the one thing I did want to add to my colleagues had to say.
Thanks. So Greg, how much does partisan control matter? Sorry, Greg, go ahead.
I was just going to echo what something that Alice just said. Even though depositions, which is a very ordinary discovery tool in civil litigation, of course, depositions can be part of the congressional investigation process. What clients oftentimes don't quite understand in enough detail, right? And we spend a lot of time explaining to clients is there's a huge difference to producing even your CEO for a deposition, whether it's in litigation or in a congressional investigation context, and producing your CEO or any witness for an open public congressional hearing. Those things couldn't be more different. They're similar in that you're answering questions on the record with a court reporter, right? But beyond that, they're totally different, and the preparation required is totally different. And so that's a huge difference. So thanks for the interruption.
No, no, it's okay. In terms of an agenda for oversight, how much difference does partisan control make especially when you take into consideration how things are much different today, partisan wise, and Republic being a Republican has somewhat of a different meaning in some contexts. Does it matter who controls Congress in terms of what the agenda looks like?
Absolutely. In the same way that it makes a difference to the legislative agenda, it'll make a difference to the oversight agenda. The other thing that makes a difference here is that the parties, that the Republican Party on January the 20th will control both the executive branch and the legislative branch in toto. So that changes the dynamic as well. I mean, traditionally, so for example, if Democrats had won the House of Representatives, you could assume, rightly, I think, that a lot of their oversight would be trained on the executive branch. It's less likely, not impossible, but less likely that a Republican majority in Congress is going to put the administration's officials under the lights, time and time again. I think they will take their shots. I was at the Justice Department when Chuck Grassley was the chairman. He's going to be the chairman of the Judiciary Committee for another 2 years. He's known for his vigorous oversight. He takes great pride in it, and I anticipate, he'll do a significant amount of oversight over both kind of the executive branch within the jurisdiction of the committee, as well as, some private parties. In that regard, I'll just name 3. These are probably the most obvious to those watching, but I think Republicans have some concerns with big tech, and I think they will probably make some common cause. There may be some bipartisan oversight in this regard. I think our information is that we're likely to see the U.S.-China Select Committee reauthorized. That's really an oversight committee. It doesn't have legislative jurisdiction. And so trade with China, technology transfer, all of the sorts of, very important U.S.-China issues that were addressed by that committee during this Congress, the 118th Congress, we think will continue into the 119th. And then I think that Republicans they've started, and I think they will continue to look at ESG programs, both in the government and in private enterprise.
Greg, did you want to add anything to that?
Well, the only other thing I think that is certainly out there and has been bipartisan in certain respects is healthcare, whether it's pharma, drug prices. The opioid crisis has been very bipartisan in terms of congressional interest, and so I think all of that will likely be a focus as well.
And there's some kind of known unknowns here, I guess you might say. Issues that are going to come up. I mean, we already see some getting increased public attention. If RFK is confirmed to be the Secretary of HHS, and he decides, to put a focus on certain additives to food, you could see Congress kind of jumping in and wanting to know more about, artificial colorings and flavorings and that sort of thing. I think the Chairman Comer of the Oversight Committee has already announced that he wants to do something that's going to mirror what this Ramaswamy, Elon Musk commission is going to do, the so-called Doge commission, and he wants to mirror that, in the Congress. And so you can see some cooperation with the executive branch as well. It kind of enhances the ability for Congress to shine a light on, one particular perceived problem or another.
Alice, in addition to looking for opportunities to do the kind of bipartisan oversight that Greg and Will were talking about, what other kinds of roles can minority members and ranking members on committees play in the context of oversight?
Yeah, the minority can do a lot. I mean, the purpose of oversight is to shine a spotlight and get public attention on a critical issue. And so even though the minority doesn't hold the gavels, they can't, call a hearing formally. They have the ability to ask questions in the hearing. They also usually get a minority witness to testify. They can have field hearings, ad hoc hearings, hold press conferences. There's a lot that can be done. And even though, minority members can't compel or issue a subpoena, they can voluntarily request cooperation, of private sector folks, companies, et cetera. And I think one issue, and Will brought this up earlier, is going to be in the DEI space. Not only did the Congressional Black Caucus write letters to companies and CEOs, so did the Congressional Hispanic Caucus, and so did the Congressional Asian Caucus. All three together are the Tri-Caucus. So this is an issue that's been front and center for them. They are holding companies to account on commitments that they have made in this space. And look, the majority in the House could flip in 2 years. And so companies need to be very thoughtful of how they're responding. When they respond, some company CEOs met with the Congressional Black Caucus and the Congressional Hispanic Caucus voluntarily had a conversation. And so that's an issue that I see these caucuses continuing to focus on. But yes, the minority can do a lot. They can make a lot of noise. They can make it politically uncomfortable to not be responsive to an inquiry, even though they don't have the compulsory process through a subpoena.
So can those that are being targeted for investigations, and especially in the hearing context, go to minority members or go to the ranking minority member in the hopes that they might not necessarily come to their defense, but at least counter some of that expected more hostile questions from the majority?
Yes, and I think depending on the topic, that could be very smart to, engage sooner, offer an explanation, offer information on the front end, either to have the minority, in a sense, back up the testimony that individual is about to give, or to clarify some sort of misinformation that could come out in a hearing, and the minority member could, bring that up in a less adversarial way. So yes.
Thank you. So Greg, let's turn to the.
And Glenn, if I could,
yeah.
Can I mention one more thing in that regard, Glenn? That is another just big difference between litigation and the way litigators typically think, and the way congressional investigations work. And that is, in the congressional investigations context, there's really no such thing as improper ex parte contacts. So as Alice just alluded to, it's absolutely incumbent that counsel representing the target of the congressional investigation make those contacts with staff, let's say before a hearing, meet with members if they can, try to, discuss the issues, get their side of the story out, do all the things that you could never do with a client in litigation. There's absolutely no such thing as going to meet with a judge or her law clerks before a hearing to talk about it. But in the congressional context, it's absolutely essential. And it's just the way it works on the Hill, and there's nothing wrong with that. It's critical to the process. Thanks.
Sure. No, just getting into the sort of here and now, the 119th Congress obviously going to be sworn in January. We'll talk a little bit about some of the things that he thinks will be of interest to Congress in general. Is there anything on the Senate side in terms of the oversight agenda that you think should be paid attention to?
I think some of it's good.
Well, I guess
Greg, actually. Sorry, Will.
Oh, I'm sorry.
Well, let me real quick, and then I want to hear Will's thoughts as well. But the couple of things I'll point to is in the Senate, of course, we're going to be looking at a complete new slate of committee chairs, right? And so with new committee chairs come new priorities and new issues, pet issues, if you will, that the chairs may have. And perhaps tried to pursue as ranking members and couldn't quite get the traction. And now they're chairs. And as we've discussed, that makes a big difference. So the three I would just kind of point to is Senator Rand Paul from Texas, of course, is now, of Kentucky, excuse me, is now slated to chair Homeland Security. And he'll bring a different perspective and different set of priorities to that. I think we'll see a lot of focus on national security issues. He has mentioned kind of going back and relooking at COVID, the origins, the reaction, et cetera. So that's one big difference. Within the Homeland Security Committee, we have the Senator Johnson from Wisconsin chairing the permanent subcommittee on investigations. And he has been clear in conversation with the media recently about his intended focus on health issues. In fact, he has described himself in the context of looking at healthcare. He has described himself as a mosquito in a nudist colony. That's the approach he intends to take, apparently, with respect to the healthcare industry. So that will be interesting to watch. And then, of course, Senator Tim Scott from South Carolina will be taking over the banking committee, and he will bring a different perspective. And I suspect he will continue to pursue many of the things that he pursued as ranking member of the committee. He's already called for a suspension of all rulemaking pending the transition. And so I think those three will be very interesting to watch, among others. But they're all new. All the chairs are new in the Senate.
Will, do you want to add something?
Just two items. I mean, the list can be almost endless, but so for example, there was a lot of talk during the campaign about crypto. I don't know if it's going to be investigative oversight in the sense that you're going to see a lot of subpoenas and that sort of thing, but there certainly will be oversight so that members of Congress fully understand kind of the role of crypto in the economy, how it ought to be regulated, and I could see multiple hearings on that. I also think Republicans are going to look for their next Solyndra and will take a look at any recipients of the very generous, grant programs that were created as part of the Inflation Reduction Act, and whether or not, how that money was used, was it wasted, that sort of thing. And then finally, we expect the executive branch, the Department of Homeland Security in particular, to be aggressive on immigration enforcement. And you could see Congress kind of getting involved, particularly on the workplace side. And I anticipate that we may see some of that.
Greg, at least during 2025, how much do you think confirmation hearings in the Senate will cut into the Senate's ability to conduct oversight, especially hearings?
Well, as with any new administration coming in, putting forth its nominees, that will be a big lift for the Senate. As we all know, the Senate committees sort of divide the labor, right? So it's all of the confirmation processes, the hearings, et cetera, don't rest with one committee. So Judiciary will have some, Foreign Relations will have some, they'll all have, Commerce will have its. But there are literally hundreds, right? I mean, DOJ alone has hundreds of Senate confirmed appointments coming down the pike. So it will take time, but the Senate is used to this process. It's a constitutional process, it's been around forever. So there's, like I said, the division of labor will happen, and the Senate will kind of do that while it's also doing legislation, while it's also doing oversight. But confirmation hearings will definitely take some time and will be part of the mix in the early days going forward. Yes.
Alice, kind of drawing on your experience with DHS and their issues, a big issue for the business community is immigration, obviously. Do you see the Senate keying in on those kind of immigration issues outside of the illegal immigration context, or do you see that there's going to be kind of a merging of those issues for hearings?
I think it's going to be both. Senator Grassley, as chairman of Judiciary, is very well versed on immigration issues, a variety of issues, specifically employment verification, E-Verify, et cetera. So I see I-9 audits being an issue that comes up. I know some businesses are already preparing and making sure their house is in order in that space. I also think on the legal immigration side, H-2Bs, which are temporary non-ad workers, and H-1Bs, which are specialty workers. I see a curtailing of those types of visas, of making it more difficult to obtain those visas, more requests for evidence, et cetera. So I think there will be scrutiny on both sides of the aisles, because these visas are important to, depending on what state you're from, for your workforce. Along also with enforcement at the workplace. I could see workplace raids coming back, and that will affect the business community, especially farm workers in certain states. If many of them are undocumented, or some of them who have visas, who's going to get caught up in these deportations, and how that's going to affect the workforce. So I think it'll be a combination, on one, the deportation force that is in the news constantly. And I think we just saw Senator Rand Paul, as Greg mentioned, he's going to be the chairman of Senate Homeland Committee, and he disagrees with using the military in our streets to enforce immigration laws and deport individuals. So I think there's going to be tension even across the aisle on some of these immigration issues in the new administration.
So, Will, shifting over to the House, the GOP kept control of the House, a little bit narrower. Do you think this means more of the same in terms of oversight priorities? Any new chairs that especially those in the business community should be looking at or being concerned about?
There will be a new chair of the House Energy and Commerce Committee, which you started this off by quoting John Dingell of Michigan. In fact, he was such a prolific oversighter, if you will, that letters from Congress that have multiple questions with tons of subparts are affectionately known as Dingellgrams. And so I'm not going to guess as to who's going to win that chairmanship fight. There's also going to be a new chairman of the House Financial Services Committee. So there will be a little bit of movement. Comer will stay at Oversight. Jim Jordan will stay at Judiciary Committee, and the two of them have worked well together. I also think, as I said, the China Committee, Select China Committee, is going to have life during the 119th Congress. What I don't know is there was a select committee on the weaponization of government. That was the subcommittee before which the so-called Twitter files hearing was held. I don't know if they're going to keep that going or just fold that work into the regular work of the Judiciary Committee. But I anticipate, they're still going to be aggressive, slightly, less focused on the Trump administration as they were the Biden administration. But it's always a target-rich environment.
That's for sure. Alice, any thoughts on the House?
I think it could be a variety of issues that come up. One that hasn't been mentioned is social media content moderation policies. I see that being under scrutiny, as well as scrutiny of colleges and some of their policies, ranging from transgender LGBT policies to anti-Semitism, how they're treating that and tying that to federal funding. So I could see a variety of those issues also coming up in the House.
Do you think that the social media content moderation, do you see that being a bipartisan issue in some ways in terms of oversight?
I'm not sure if it'll be bipartisan, but going back to the Senate, Senator Rand Paul, the new chairman on Senate Homeland, mentioned potentially getting rid of CISA, which is the Cybersecurity and Infrastructure Agency, for their efforts to counter disinformation. He's viewed it as singling out conservative voices, and CISA has responded that they've never censored free speech. And so I see that issue coming back up. I think Senator Paul is going to have his work cut out for him if he does want to terminate that agency. I think both Republicans and Democrats have appreciated the mission of that agency. And so I think that will be an issue that will be difficult and will come up.
You know, one area where there's some potential risk for business is, you know, how closely they worked with departments and agencies of the federal government, particularly during the Biden administration, on certain matters. And so, for example, as Alice is talking about content moderation policies, you know, there was some oversight over that, but I don't think Republicans believe that they've got the full story. And so they could ask the FBI, this short-lived office that was, Alice can correct me if it was actually ever stood up, but that was supposed to deal with disinformation issues. You know, I think that these new landing teams are going to come in and they're going to try to uncover what they can uncover. And I think committees of Congress will keep those oversight avenues alive, in part because then, you know, that information could be submitted by the new leadership of those departments to congressional committees. And if they find that, you know, this bank or this social media company or this this other business was somehow involved in a way that they believe, you know, what helped weaponize the government, to use their term, against a certain group of individuals, then that's going to be an area of continued oversight.
To remind everyone that if you do have questions, please put it into the Q&A function. Will, the House and Senate committees can conduct and have obviously conducted considerable oversight of the executive branch, especially regulatory agencies. Do you see this Congress undertaking any kind of oversight like that? And if so, how do you think that might affect the business community sort of writ large?
Well, again, I think they're not going to do it as much of the new administration because Republicans are going to control both sides, but it might be a little bit retroactive. And so to the extent, so for example, you asked a question about who might be a subject or a target of an investigation. I can tell you who should be breathing a little bit easier these days, and that's, you know, energy companies. Maybe not the clean energy companies, particularly if they received, you know, big subsidies or tax breaks from the Biden administration, but energy companies generally should have a bit of a reprieve, less focus on climate change. That being said, there may be some issues that are uncovered at the Department of Energy or the EPA that bear on the policy priorities of Republicans, where you could see some oversight and some cooperation in that regard between the executive branch and the legislative branch.
So Greg and Will have written a couple of blog posts for our WF Legal Pulse blog on contempt proceedings being instituted against the corporate CEO for failing to appear before a Senate committee despite being subpoenaed. CEO then turned around and sued the committee. How unusual are both of these developments? And Greg or Will, whoever wants to start on this, definitely be interested in hearing some perspectives on that.
Yeah, I can start, Glenn, and then turn it over to Will. It is unusual, to answer your question. The short answer is yes, it's unusual. As we've alluded to, the subpoenas, congressional subpoenas, can come with some potential enforcement. Contempt of Congress is kind of the ultimate enforcement, at least on the congressional side. In this case is an example of the potential for a criminal referral by Congress to DOJ to then prosecute the contempt, which can be a misdemeanor offense. And so that's what happened here. There was a corporate CEO was subpoenaed. This was very bipartisan, which is you know, the way things that get ratcheted up this much typically would be, right? Bipartisan effort to enforce the subpoena after the CEO's no-show. And then he turned around in an effort to preempt DOJ charging him He sued in district court, federal district court, seeking to have the court enjoin DOJ from doing so, declaring the subpoena essentially null and void. So yes, it is unusual, but it's a textbook example of where things can go when the target of a subpoena does not cooperate and there's enough bipartisan interest in enforcing the equities of Congress. This is what can happen. So, Will, you've been around this a long time. You may have thoughts as well.
Sure, and then there are the other two previous cases that come to mind are Peter Navarro and Steve Bannon. The one thing that ties all three cases together is that they didn't cooperate at all with the Congress, and usually not a great tactic. And so Navarro and Bannon were convicted, did some jail time, and then we're waiting on this third case. But it doesn't happen often. There is, and you see this more in inter-branch disputes or civil actions between the branches to enforce compliance. You won't see a cabinet secretary go into jail, usually because he's got a legal opinion from the Office of Legal Counsel at DOJ saying that the materials being subpoenaed are subject to executive privilege or deliberative process privilege or some other defense like that. And so those disputes usually are resolved civilly. There is a power of Congress, hasn't been used in over, let's see, is it over 100 years yet, Greg? Almost 100 years.
Almost.
Inherent contempt, almost like the inherent authority of a judge. But in the past, contemnors have been arrested by the Sergeant of Arms, tried at the bar of the House, and then jailed until they've decided to comply with the request. But inherent attempt is really something from a bygone era.
And one thing to note,
I'm sorry, go ahead, Greg.
On the criminal contempt issue we were just discussing, one thing to note is that even when Congress does refer a matter to DOJ and DOJ does successfully prosecute it, as was done with, as Will mentioned, with Bannon and Navarro, it doesn't mean that Congress gets the information it was seeking necessarily. The contemptor is punished, and in those cases with some jail time, but Congress doesn't necessarily get their testimony or their documents. That's how that ends typically, with punishment but no cooperation at the end of the day. So
I'll throw a couple of questions out here from our audience. First one is, any chance the filibuster is going away?
I don't think so. I mean, first thing after, Senator Thune was elected majority leader, I think it came up in the press gaggle, and he, pretty much said the filibuster is safe. So I don't think it's going away, but we shall see. I don't know, Will, Greg, any thoughts there?
I agree. It's safe for another 2 years.
Yeah. Some things are still sacred up there. Not many things, but that seems to be one.
And we should be clear, we're talking about the legislative filibuster, because nominees now cannot be delayed indefinitely.
Right. Any predictions on the recess appointments possibility is another question.
That's a really good question. Look, a lot of ink is being spilled on this. My personal view is that it'll actually bog things down more than speed them up, particularly if you're trying to pursue if the president or his team is pursuing a new strategy, for example, the one that's been discussed in invoking Article 2, Section 3 of the Constitution. And I'd also be worried that, if my recess appointee is in office and takes, a number of final agency actions, those could be put on ice if the courts ultimately decide that the person was installed in an illegal, unconstitutional manner. So I tread carefully here. I mean, I think the Republican majority in the Senate is committed to moving the president's nominees. And the president has an aggressive agenda. And I think that it behooves them to, utilize the current process and not talking about it bogging down before it's even really started.
Yeah, I would
Greg,
agree with that, Glenn. I would agree. This is the scenario that's being proposed is obviously not the classic recess appointment scenario. And so senators are looking at this, I think, without a lot of enthusiasm. For all of the kind of cynical commentary lately about a shift from the separation of powers to a separation of parties, and we've seen plenty of that. I think Republican senators are institutionalists at heart. At least enough of them are, and as Will said, they will do their duty to consider the president's nominees in due course and in a timely fashion. And they would, I think, as a group, generally push back on something novel like using recess appointments in a non-traditional way.
Another question is, does the potential focus on safety / additives in food hinge on RFK's confirmation, or is it likely that will be a priority either way? That's for anyone who'd like to.
Yeah, I don't know how it shakes out. He's certainly going to be asked about it. And I think he's got, 30 years or more of public statements that he's going to be asked about. So this will be one of hundreds. One of the things in congressional oversight that we didn't talk about are post-hearing questions. Insiders call them QFers, or questions for the record. I think RFKs are going to be this thick. He'll have a lot of questions to answer. And Glenn, could I just mention one thing, a question that hasn't been asked, but that I get sometimes asked in these forums, which is, what is a mistake that businesses sometimes make in responding to congressional oversight? And I would say this: don't view the response solely as a legal matter, particularly if it's kind of a high profile, the letter or the subpoena went out, it went right to the press, and it looks like, this is going to be a front page story for a day or two. You need to bring three different tools to bear. One is legal, one is lobbying, so just going beyond negotiation with the oversight staff, but really working the rest of the committee and the rest of the Congress, and then of course a public relations side. So oftentimes in these matters, firms will engage lawyers, lobbyists, and a public relations firm to make sure that they're given 360 coverage on all the various aspects that come into play on these sorts of high profile matters.
Who puts together those follow-up questions, Will? Just out of curiosity, is that just the majority or the chair, or does the minority have an opportunity to craft questions or ask questions separately?
Everybody, yeah, everybody. If you're a member of that committee, you can submit questions. They're usually drafted by the senator's staff. Senator might bank some out, him or herself, but usually those are staff questions. But after a discussion with the senator about what they're interested in.
And I would add that congressional staff hears from outside parties. They hear from outside groups about, hey, can you ask this for the questions for the record, or companies or businesses. So they hear from a variety of groups. Ultimately, it's their decision in consultation with their member. But it's a spot to weigh in with congressional staff on that.
Greg, sorry, you look like you wanted to add something.
I was going to echo exactly what Alice just said. So yes, very important point.
Wanted to note that we will be, Washington Legal Foundation will be putting a paper out by our three speakers on Monday on congressional oversight. We'll make sure that everyone who tuned in today gets a chance to get a copy of that. I want to thank you all for joining us today. Alice, Will, and Greg, I think we covered a lot of ground in an hour. which is not easy to do. Like Will said, we could have done a full hour just on the congressional oversight process. But thank you for keeping your answers brief so we could get through quite a bit. For those of you who are still on, when you sign off, there'll be a survey. If you don't mind taking that real quickly, we'd really appreciate it. And if you have any questions for the speakers or for me, feel free to shoot them ahead in email. Thank you again for joining us, everyone.
Thank you. Take care.